Good morning, everybody. Welcome back. Good to see everybody. New day, new week, new piece of legislation, new level of enthusiasm. So let's get underway here. So call to the meeting to order. Welcome to meeting number 21 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of February 2nd, 2026, the committee is meeting to begin its study of Bill C-16, an act to amend certain acts in relation to criminal and correctional matters, child protection, gender-based violence, delays, and other measures. Today's meeting is taking place in hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I'd like to confirm the sound tests were done successfully. Everybody knows the guidelines that are in front of them on the desks, of course. And then I would like to make a few comments for the benefit of witnesses and members. Please wait till I recognize you by name before speaking. For those participating by video conference, Mr. Housefather, you know the routine. I don't think I need to go through all of the details. So I will skip that, and I will jump to welcoming our witnesses. First of all, we have the Honourable Sean Fraser, Minister of Justice and Attorney General of Canada. Welcome, Minister. Thank you for attending today. The Minister will be with us for the first hour. He's joined today by Department of Justice officials, Owen Ripley, Senior Assistant Deputy Minister, Policy Sector, Matthew Taylor, Senior General Counsel and Director General, Criminal Law Policy Section, Natalie Levman, Senior Counsel, Criminal Law Policy Section. Minister, I will turn the floor over to yours for your opening comments, and thank you for being here.
Oh, and how long, Mr. Chair, for opening comments?
He has 10-minute max.
Okay, I will endeavor to be shorter than that to leave more time for questions. Thank you. Thank you, Chair and colleagues, for being here at committee to discuss Bill C-16, the Protecting Victims Act. This is an important piece of legislation that I do believe is going to improve safety outcomes in a number of different contexts, including gender-based violence and the protection of kids online, in addition to certain other changes that will, in my view, strengthen the capacity of the justice system to respond to pressing social challenges. Juste avant de commencer, je pense...
Before I begin, I think it would be useful to give a bit of context about this bill and how it was sent to the committee. We have a strategy to protect the public and enhance public safety. The strategy includes three categories.
Strengthen criminal law reforms to ensure that we have laws in the criminal code that are designed to enhance public safety and ensure that serious crimes are met with serious punishments. The second pillar of this strategy is really focused on supporting the front line. This could include 1,000 new RCMP officers, 1,000 new border officials, but it also includes giving law enforcement the tools that they need, whether that is more recently Bill C-22 or other authorities that will help them investigate, prosecute, and protect the public against crime through prevention efforts. The final pillar of the strategy is really on making the upstream investments to help build healthier communities and healthier people in the long term. This is where we're talking about investments in mental health and addictions, affordable housing, in programs that target at-risk youth to ensure that as you build healthier people and healthier communities, you have a long-term opportunity to reduce violent crime in Canada. Today's bill really falls under that first pillar, strengthening criminal laws in this country. There's a number of different themes that I hope to draw your attention to. Of course, there are several dozen different measures in this bill, I believe 83 distinct changes, but I'm going to focus on a few key ones. Premièrement, je veux
First of all, I want to talk about the importance of addressing femicide in this country. When I read stories in the newspaper about, 7 femicides in Quebec alone this year, I thought it was a real tragedy. We need to take action to fight femicide, not only in Quebec, but all across the country.
Injustice taking place in this country when it comes to the murder of women, often at the hands of their intimate partner. We have an opportunity to respond by creating a constructive first-degree murder charge in cases of feminicide. This will include murders that are committed in certain different contexts, including hatred-motivated murders, where someone is targeting a victim, for example, on the basis of their gender. This also includes murders that will be committed in the context of a coercive and controlling relationship. It will also include murders that are committed in the context of the commission of a sexual offense. I do want to pause on the issue of coercive control for a moment, because in addition to it being a qualifier for that first-degree, constructive first-degree charge in cases of feminicide, we've made the decision in this bill to move forward with the criminalization of coercive control as a standalone offense. We want to do this because we have an opportunity to have the justice system intervene before a relationship becomes violent and before violence becomes fatal. We have seen through our engagement in the preparation of this bill, time and time again, those who have spent their lives and careers studying the issue, citing coercive and controlling behavior as being predictive in terms of future violence that may take place in the household. We are not talking about ordinary facets of a healthy relationship. We are not talking about arguments over who's going to manage the household finances. We are talking about behaviors that would reasonably cause a person to fear for their physical or psychological safety. In addition, this bill makes changes to the charge of criminal harassment, ensuring that it's both modernized for new technologies, but also that we've shifted the test towards an objective rather than subjective standard, given the feedback that we heard about how difficult it can be for victims of criminal harassment to actually demonstrate what they in fact felt rather than what a reasonable person would feel in the circumstances. There are a number of other issues in this bill that I want to draw your attention to, including the creation of a number of new sexual offences. In particular, I direct you to portions of the bill that speak to changes in regards of Canada's criminal laws insofar as they impact the distribution of intimate images. We are changing the law in two key ways that I'd like to focus on. One is to ensure that the criminalization applies not only to the distribution of these intimate images without consent, but also the threatened distribution of those images. There's one other feature that has found itself in the news for perhaps obvious reasons. Our laws need to have the ability to keep pace with changing technologies in this country. We've seen a preponderance of cases making their way through our communities, into the newspapers, and occasionally our courts, involving the use of artificial intelligence to create deep fakes of intimate images that bear the likeness of a person known to the prospective offender. I say prospective because the criminal code does not necessarily recognize today the use of AI deepfakes the same way that it would intimate images that are captured through other technologies. In my home province of Nova Scotia, very recently, we have seen a judge dismiss charges against an accused person on the basis not that the act was not heinous or morally culpable, but that the criminal code does not include within the definition of intimate images those which are created through the use of artificial intelligence. This bill proposes to change that, to deliver justice to victims who are having their likeness used for such an inappropriate and morally culpable reason. And with the modernization of the criminal code, we will be able to ensure that these behaviors are captured and that the wrongdoers are punished for their actions. In addition to certain new sexual offences that are being established, we also are going to be increasing the penalties for certain sexual crimes, including voyeurism, summary sexual assault. We will be looking at a number of other matters when it comes to sentencing as well. By and large, these changes are made to provide equity as between existing provisions within the code to align the maximum sentences in some charges with the maximum sentences that pertain to other charges that take place in a sexual context as well. While we're on the subject of expanding the maximum penalties, this bill also takes significant steps to restore mandatory minimum penalties for a wide variety of crimes where a mandatory minimum penalty has either been struck down or where it maintains its place within the criminal code today, but carries with it constitutional vulnerability as a result of the treatment by the court of mandatory minimums that existed previously. Now, this is a response very directly to the Senville decision that we've seen from the Supreme Court. And we made the decision to restore these mandatory minimums, but take the court's direction with the creation of a safety valve only for those circumstances where the mandatory minimum would be grossly disproportionate. It's important that we ensure we have the constitutionality protected of these provisions if we actually want the provisions to be useful. The provisions that exist today are offering no protection to anyone because the court has indicated that they will be struck down when challenged. We have found a way that not only reflects the feedback included in decisions of the Supreme Court, but part of the reason we chose this particular approach was the public statements that we've seen in the House of Commons and elsewhere from members of both the Conservative Party of Canada and the Bloc Québécois. Our desire was to find a path forward that would gain multi-partisan support to ensure we could address this particular issue professionally and in a way that would carry the test of time. There were other strategies that we've looked at, but for reasons that I'm happy to get into for questions, we've chosen to move forward with the strategy outlined in the bill itself. There are other changes that we made as well, particularly to protect kids against exploitation, including in an online environment. This includes changes to sextortion, including not only the distribution, but as I mentioned in the context of intimate images, the threatened distribution of child sexual abuse material. It also involves changes to child luring provisions within the code to ensure that they are incorporated within the definition of sextortion for the purpose of this bill. There's a series of other penalties that range from depicting bestiality to inviting exposure to a series of other measures that impact on mandatory reporting and other facets. But suffice it to say, we've taken feedback from stakeholders who have made it their life's work to protect victims. Mr. Chair, I have one item I'd like to complete before I finish with the time that I've been allotted, and that's on the issue of delays in the court process. We've seen over the last number of years, according to news reports, nearly 10,000 cases that have been dismissed for delay, not because a trial has come to its conclusion and had a not guilty verdict rendered, but instead stays of proceedings issued. This often comes up in complex drug investigations, but it also comes up often in sexual assault contexts. And it's never felt like justice to me that the potential perpetrator of a crime would benefit from a stay, allowing them to live in the same community where the victim resides. This bill proposes to address this challenge in a number of different ways. One, by addressing delays directly by seeking to streamline procedure, but others in other ways to encourage the court to use a lengthened timeline for complex cases, but as well, when that time is hit, to consider remedies other than a stay of proceedings. Monsieur le Président, je pense que c'est proche de 10.
Chair, I believe I'm close to the 10-minute mark, so I'd be happy now to give you the floor so that I can take some questions from committee members. Thank you.
Thank you very much, Minister. Okay, we'll start the first 6-minute round with Mr. Brock.
Thank you, Chair, and thank you, Minister, for your attendance as well as your officials from the department. Minister, after a decade of catch-and-release Liberal bail, repealing mandatory minimum penalties, and other hug-a-thug laws, Canadians are understandably scared. Since 2015, human trafficking has increased by 84%, sex assaults are up almost 76%, violent crime up almost 55%. C16 egregiously continues the Liberal soft-on-crime agenda by empowering judges now to ignore literally every mandatory prison sentence in the criminal code other than murder and treason. Liberals are now trying to allow judges to ignore them for aggravated assault with a gun, human trafficking, and multiple firearm offenses, including extortion with a firearm, weapons trafficking, drive-by shootings with a restricted or prohibited firearm, and more. Parliament, Minister, sets mandatory minimums for these heinous crimes for a reason. But if your government allows judges to ignore them, there will be nothing mandatory about it, period, full stop. The passage of this provision would be a total abrogation of our duty as elected representatives to keep our communities safe. Conservatives will never vote for lighter sentences for serious offenders. Will your government immediately split off this poison pill so we can all get back to work making this bill better and keeping Canadians safe?
Thank you, Mr. Chair. And I have respectfully a different point of view from my honourable colleague in terms of the value that this bill is going to offer more broadly. I take the closing comment in his question as a endorsement, at least, of some measures within the bill, if not the provisions that apply to mandatory minimum penalties. On the issue of mandatory minimum penalties, though, there's a particular piece of context that we need to understand. Because I know the member asking the question believes that the government should adopt laws to protect against the harms he's enumerated. I share that desire, sincerely. We all want strong penalties for serious crimes. But we have to ask ourselves, what value is a mandatory minimum that exists on paper that is not recognized by law after decisions by the court striking down those mandatory minimums? If our laws written into the code are not enjoyed in our communities, then those laws are not with the paper, are not worth the paper on which they are written. Today, the mandatory minimums that include those that were subject to the Senville decision offer no force of protection for Canadian victims. We might feel good about what the code says, but if the court is going to strike down those provisions and not incorporate them into the sentencing regime, we can't say that there is a functioning mandatory minimum regime today. We made a decision to restore those mandatory minimums, taking the constitutional guidance from the court, so they will actually be put in place and will demand reasons from the court in circumstances where they deviate from the mandatory minimum. Keep in mind, we're not dealing with some widespread discretion. We're dealing with circumstances that are so excessive as to outrage standards of decency, in the court's words, or that would be intolerable to society. We think we found the right approach.
Thank you, Minister. A glaring omission in Bill C-16 is the lack of reintroduction of the 15 offenses that your government, that you voted for, Minister, in the passage of C-5 in the 44th Parliament. Will your government reintroduce all those mandatory minimum penalties for those offenses that were removed?
Mr. Chair, one just sort of historical development piece of this bill that's important to understand is the Senville decision arrived as we were preparing the contents of this bill. We made the decision to respond, and we thought it best to address the issue of mandatory minimums that existed today, that were baked into the code previously, including those that remain in the code and those that were struck down. We didn't do a full-blown consultation about either provisions that had been removed by Parliament or those which could potentially be added or removed from a mandatory minimum regime. If that's an issue that this committee would like to study to provide guidance, I would welcome that guidance, but it would be important to actually conduct that consultation.
Only reason I raise this is your predecessor, David Lametti, was very proud of the fact that mandatory minimum penalties do not work. In fact, he's quoted numerous times, and the quotes have not aged well over time, given the rising crime levels in this country. But I put to him the very possibility that the Supreme Court of Canada could be upholding mandatory minimum penalties that C-5 removed. I raised that as an issue, and sure enough, after royal assent of C-5, the Supreme Court of Canada in the Hill and Hillback joint decision upheld the mandatory minimum penalty that was removed by C-5. So given the Supreme Court of Canada has upheld a number of mandatory minimum penalties that have been in the existence of the criminal code since the late 1800s, why would this government not take an opportunity? The 15 classes of offenses that you removed in C-5 are very significant violent offenses, including every single drug offense under the Controlled Drugs and Substances Act. Why wouldn't this government take an opportunity to strengthen our criminal laws as opposed to weaken it?
So I don't view Bill C-16 to weaken Canada's criminal law for the reasons that I've articulated in the opening set of remarks. It strengthens them in a number of particular ways. Back to the question that you've asked, when we were moving forward with the decision to address the consequences of the Senville decision, we were dealing with the umbrella analysis around the protection of mandatory minimum penalties as across offenses. We did not do
yourself, Minister.
All right, Mr. Brock, you're actually out of time. I was just allowing me an opportunity to answer your question. So.
Thank you.
happy to address further in response to subject.
If you want to finish your answer. Minister,
Look,
quickly.
only that if you're going to add or subtract particular offenses from a regime that purports to impose mandatory minimum penalties, you should appropriately engage with stakeholders, with experts, with law enforcement to understand which provisions are going to have the most meaningful impact. That would be an excellent task for this committee to take on should you wish Mr. Brock to make further recommendations. Having not done that policy work, given that it was outside of the scope of the initial intended range of measures included in the bill, I don't think it would be appropriate to start adding new offences to that regime without that policy work being done in advance.
Thank you, Minister. Thank you, Mr. Brock. Mr. Chang, 6 minutes.
Thank you, Mr. Chair. Thank you, Mr. for being here and for your leadership on this important legislation. Bill C-16, the Protecting Victim Act, reflects our shared responsibility to ensuring that victims are better protected and supported within our judicial systems. Canadians expect a system that's fair, compassionate, and responsive to those who have been harmed. In my riding of Burnaby Central, many of my constituents have shared their concerns about safety, accountability, and the need to better protect vulnerable people, particularly those, in the face of evolving threats. I appreciate the work that has gone into this bill and the focus on strengthening public confidence while upholding the rule of law. With that in mind, Mr. Could you begin by outlining the main purpose of Bill C-16 and why the government believes that the reforms are necessary at this time to better protect victims and vulnerable people?
Certainly, and it's a bit of a complex question to unpack because there's a number of different policy areas that this bill does cover, and the motivation between within each policy area may be slightly different. If I could maybe boil it down for the purpose of simplification, a significant portion of the energy that's been dedicated in this bill is really focused on the problems that we're seeing with intimate partner violence in this country. It's egregious to me, the level of violence that we are seeing facing Canadian women and the routine nature in which we see stories in our newspapers where that violence is perpetrated by too often a man who is in a relationship with the victim. When we hear calls for the government to take action to address femicide more squarely, we're not dealing with a philosophical issue. We're dealing with cries for help from families members who are dealing with the years not lived of their most closely held loved ones. When we're dealing with coercive control, we are hearing from women who may have escaped violence, hoping that they can offer protection to other women who are in similar circumstances. When we hear about the need to change the laws around criminal harassment, we're responding to very real calls for action where people have gone through the process but been unable to meet an evidentiary standard, notwithstanding the fact that they've not been able to live safely in their communities. Similarly, with the mandatory minimum penalty regime, we want it to deal with the world that we actually live in, not some hypothetical version of it where we can ignore the decisions that were taken by the courts, which we have an obligation to respect as elected officials. We wanted to ensure that we had those mandatory minimums in place to say there will be serious consequences for serious crimes, while we respect the nature of the court's decision with respect to safety valves for those circumstances that would result in a consequence that the public would find intolerable. There are other changes that were motivated with shifting technology, again on criminal harassment and AI deepfakes, making sure that our motivation is to offer protections that we always thought would exist, but recognizing that the laws need to be updated to reflect modern tools that are being used to commit morally culpable behavior that may be outside of the definition of the crime. And finally, because I don't want to eat up all of your time, Mr. Chang, the prevalence and expanding rate of exploitation of children online is something that we need to address. As a parent, I have grave concerns about the ability of people who would do harm to engage with kids the age of mine. We have to adopt protections that will recognize that these heinous behaviors take place in our communities and offer protections against them. We can't lose sight of the fact that this bill is one part of a larger, broader strategy that will seek to end violent crime in our communities, but those are the kinds of motivations that justify the introduction of this bill.
Thank you, Mr. As technology continues to evolve, we have been seeing new forms of harms emerge. Could you outline the bill, how Bill 16 updates the criminal code to respond to crimes such as extortion and the creation and distribution of sexual deepfake?
Yeah, well, look, let's dig in on this issue. There's been a couple of decisions rendered by courts that point out the fact that the use of AI deepfakes to create intimate images without the consent of the subject of that image is a horrible behavior that demands action. It's rare that the courts will so clearly point out the need for legislative change to address a particular social harm that they witness and agree is bad, but cannot do anything about because courts recognize the limit of their jurisdiction does not extend to rewriting the offenses included in the criminal code. We have an obligation to respond when people are using new technologies to commit old crimes. We have to update our laws to reflect the changing nature of technology. It's not just present, by the way, on the use of AI deepfakes when it comes to intimate images. It's also present when you're looking at criminal harassment, when people are increasingly using cell phones to track the whereabouts of their partner without their knowledge, potentially. You also see people threatening to distribute through online means child sexual exploitation and abuse material. If we don't update our laws to reflect the changing nature of technology, we might feel very good about ourselves for what's written on paper until we learn about the severe harm that's befalling innocent Canadians that could have otherwise been prevented.
Thank you, Minister. Many stakeholders and community organizations have called for stronger tools to deal with intimate partner violence and coercive control. Could you speak as to how Bill 16 responds to those calls and why the measures are so important?
Certainly. So I addressed in my opening remarks some of the changes that we're making to femicide, creating a constructive first-degree murder charge to demonstrate that we will take hate-motivated murder as seriously as any other crime in the code, that we will deal with murder committed in the context of a sexual offense as seriously as any other crime in the code. We want to demonstrate to Canadians that we will not tolerate this kind of this most heinous version of murder that exists. But we also want to not just focus on punishing crime after it takes place, but potentially having the justice system intervene earlier in the process. This is where changes to the new offense of coercive control come in. When you know that there is certain behavior that is predictive of violence, potentially predictive of fatal violence, we have an opportunity to intervene that would lead to criminal charges for the offensive behaviors that we know often precede violence, that often precede murder. So when we have an opportunity to address these kinds of needs, we must take that chance. I should, by the way, take the opportunity to offer my thanks for the collaboration of Mr. Caputo on his private member's bill, which complements some of the measures included in Bill C-16 in response to a horrific tragedy that came out of British Columbia, the case of Bailey McCourt. When we work together across party lines to address a problem of common concern, we can offer more protections for vulnerable people.
Thank you. Mr. Fortin, for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Minister, good morning. At the Bloc Québécois, we read this bill, and we're fairly open to it. We think that there will be some amendments to bring forward, but overall we think it's a good bill. Now, I have a few questions. The question of calculating judicial delays. We all agree that I think we all agree, the Supreme Court was right to say that 2 years for provincial court cases or 3 years for superior court cases are reasonable limits. And we should be able to, conclude a trial within that time frame. However, there were people accused of violent crimes, really heinous crimes, and these people have been released because they were not able to finish their trial within a reasonable time frame. It just doesn't make sense. We need to do something about it. Now, as Minister of Justice, this directly concerns you. The Bloc Québécois tabled a bill in the previous Parliament that essentially said for serious crimes, violent crimes, there could be an exemption to that timeline. And there could be a new provision in the criminal code saying that, in circumstances where you had these violent crimes, there should be an exemption. Unfortunately, that bill died on the order paper when Parliament was adjourned last spring. And we end up today with a new proposal that essentially would recalculate how those delays or would change how the delays are calculated. So I'm not sure that's the best approach. I'm wondering, Minister, if it would not be better to have a similar provision to what we were proposing that would allow the courts to use a Section 33 exemption to change those limits in extreme cases when it really is necessary, to say that those Jordan ceilings do not apply. Do you think that would be a good idea? I have a different approach, but I agree with the idea that we need to address particular circumstances when the trial ends without a verdict. But there are two strategies within this bill to deal with delays in general, first of all. Now, we agree delays are a problem. In cases where Jordan ceilings apply, these are often complex cases. But, you know, delays don't provide justice to the victim or to society as a whole. To address the situation, we are proposing new rules
time to trial, procedurally to address the underlying problem of delay. Separately, we're also trying to deal with the consequence, not only by calculating time in a particular way or excluding certain applications, but by directing the court to consider remedies other than a stay. I prefer this approach to using Section 33. I think it is cleaner and has an opportunity to address the situation. But if the committee has an opportunity to engage on the best way to address the delay issue, I would welcome the feedback of this committee and for those in the Senate who may be watching. I really do believe in the process of Parliament, and I would welcome testimony supported by expert witnesses as to the best way to address delays. But the approach laid out in C-16 was my preferred strategy.
J'avoue que j'aime bien moi aussi cette idée-là de.
I also like the idea of tightening the rules to avoid, whenever possible, having trials end without a verdict, particularly in the extreme cases. But nonetheless, there are situations where that won't be possible. And even if we would dearly wish for it to be the case, it won't be. You know, when we talk about reasonable delays, the idea is not only to benefit the victim, but the accused as well. If the accused is innocent and it takes 5 years for the ruling, well, that's not good. And if he's guilty and it takes 5 years, it's not good for the victim. And it also has an impact on how things are calculated. So no one wins. It's expensive, it's long, no one wins. So again, if you have an extreme case where you've studied all the different options, would there not be, if there's no way to have the trial within a reasonable delay, could we recalculate? Or should we at least try to say, okay, in this case, exceptionally, this, you know, we will make an exception, and this way maybe we will prevent another woman from being killed by her partner. So would you not say, Minister, that in these extreme cases, if there's no other way of doing things, we should use Section 33 to create an exemption?
But before I go to that particular remedy, I have to ask myself, because it's very serious when you invoke the notwithstanding clause. It's a decision to say we're going beyond what would be reasonably justifiable in a free and democratic society, and I don't take that lightly. There are components to this bill that address the issue in a slightly different way, and I think will actually address the problem in a way that I believe will be effective. Time will tell. But specifically, we didn't just look at the seriousness of a crime, but instead the complexity of the nature of the charge that comes before the court. Because it's often the complexity, not the seriousness of the charge, that brings the delay to a standard that is unacceptable according to the timelines in the Jordan decision. We tend to see them in cases involving organized crime, complex drug trafficking, where there's a preponderance of evidence from different sources, often of a digital nature. Increasingly, we're seeing them in sexual assault cases, which have a very complicated evidentiary regime, which we're also trying to address in this legislation. So by actually extending the permissible timeline for those complex cases, I think we can solve the problem without necessarily resorting to the reliance on the notwithstanding clause in order to address a problem that you and I agree is a very serious problem that we must address.
Thank you, Mr. Fortin. Mr. Baver, over to you for 5 minutes.
Thank you, Chair. Attorney General, welcome back. I want to leave politics aside for a sec and just have a legal chat. I think you went to Dalhousie Law School, right? I went to Western, and I have a very vague recollection of first-year constitutional law, so I hope your memory is better than mine. Here's what I remember about how the Charter was born. Attorney General Jean Chrétien sealed the deal with the notwithstanding clause with Section 33. He agreed that in our Westminster parliamentary system, Parliament is supreme. And because Chrétien was a gentleman, he had faith that Section 33 would not be used willy-nilly and would only be used in the most extreme cases. Are you with me so far?
I'm with you, yeah.
Thank you. So to start, you would agree that you and I could come up with a scenario where the invocation of the notwithstanding clause would be appropriate.
I would like to see what that scenario is before I agree in the abstract.
But you will never. But you would not say that you would never invoke the notwithstanding clause. That there could be an extreme scenario, such as one that Chrétien contemplated, that would make you invoke the notwithstanding clause.
Well, I don't like to deal with these things in the abstract. Perhaps that's the legal training that you referred to. But if you can put an example to me, I've not seen an example where I believed it was necessary.
So let's talk about Jean Chrétien's example. Jean Chrétien's example was if the Supreme Court was to say that possession of child pornography is protected by freedom of expression, and that would lead to absurdity, an absurdity of the type that should be struck down by the Supreme Court. If they were to say that, that would be absurd, right?
Look, I feel like what you're trying to do is engage on a philosophical debate about the notwithstanding clause in the abstract. But what's important is we have an opportunity with a bill that's designed to combat intimate partner violence and exploiting kids online right now. And I feel like we're, frankly, and with respect, wasting our time on an issue that's not actually going to advance the cause of the legislation.
If I may, I'm talking about Centerville. I'm talking about the reason that prompted, and you specifically said that you've considered Centerville in Bill C-16.
Certainly.
Let's look at what happened with the co-accused, Matthew Nod, who pled guilty to possession of more than 250 videos involving the rape of children aged 5 to 10. And the Supreme Court struck down the mandatory minimum sentence for Nod and agreed to maintain, not interfere with the 9-month sentence that the court below, the first instance court, has imposed. And I suggest to you, would you not agree that striking down the mandatory minimum sentence in a situation where you have 250 videos of children being raped is the type of absurdity that Chrétien potentially had in mind?
So you and I agree on the heinous nature and unacceptable nature of the behavior that you've described, and I think we equally want to stamp that behavior out of Canadian society. Where I think we have a point of disagreement is on the correct way to address that problem. I believe the changes that we're making in this law will actually address the issue that you're dealing with, because the Supreme Court, as you will know, will strike down a provision not based on the facts before the court, but a reasonable hypothetical that could emerge under those rules. With the changes that we've made, I believe we will have protected the mandatory minimum for the heinous acts that you've described, because that person should face serious criminal penalties. And I have faith after this bill is adopted into law that we won't see that same circumstance play.
Attorney General, I think you're doing the opposite. You're undermining the mandatory minimum sentence by allowing for judicial discretion.
But the mandatory minimum doesn't apply. It's been struck down.
If I may just finish. But you have the ultimate safety valve against absurdity, which is the notwithstanding clause. And I submit to you respectfully that protecting children from rape is your most important job. And this is not just about children being raped in the videos that Nod was watching. It's about children that will be raped in the future because your government is failing to crack down on this heinous industry, which it can't do through deterrence. So why wouldn't you impose a mandatory minimum sentence for child pornography?
So in the circumstance, this is very, very important. We agree equally that that behavior needs to be addressed, including with stronger criminal penalties for people who would abuse and exploit our children, full stop. The laws that we are adopting in C-16, should this committee and the two houses of Parliament adopt them, will offer the kind of protection that you're looking for. The only difference that you and I share an opinion on is where the penalty would be intolerable to society. There should be some discretion
I
for
have
the
about
court.
20 seconds.
Actually,
If
you're out of-
you will
you're out
not
of time, Mr.
No,
Barber. You
I
have-
believe
you-
I have another 20 seconds, Chair.
Well, you don't. I'm sorry.
If you would not impose the
Mr.
clause
Barber,
here, you
Mr.
will never
Barber, you're
impose
out
the
of- you're
clause.
out of time,
That's my
Mr. Barber.
point.
Okay.
If you would not impose
Ms.
the
Dillon, the
clause
floor
on
is
this
over.
decision,
Mr.
you will
Barber,
never
you're out of
impose
time.
it.
Ms. Dillon, over to you, please, for 5 minutes.
Thank you, Mr. Chair, and thank you to the Minister and officials for coming today to committee. You spoke briefly, Minister, about technology and how it's rapidly changing. First, there was sextortion, intimate distribution of images without consent. Now there's AI deepfakes. Technology is rapidly increasing. We are addressing what is currently the technological landscape of what happens online. But my question to you is, since technology is so rapidly changing, are there any safeguards in the legislation that would automatically address the rapidly changing technology so that the law can keep up as well?
Yeah, and let me build on my response to Mr. Chang's questioning. I think there's obvious, very direct examples, including in this legislation, in terms of how we can modernize Canada's criminal laws to better address emerging threats that have come to light as a result of shifts in technology. We've cited a few times during this committee meeting so far the prevalence of AI deepfakes and the extraordinary phenomenon of courts proactively raising the prospective need for legislative change in order to criminalize this behavior, which is arriving before them. In addition to that change, I've cited the changes to criminal harassment that will make it easier for courts to move forward with convictions if somebody's been using modern technology for GPS tracking, for example, in the context of criminal harassment. This comes up again in an increasingly digital space when it comes to the protection of children against child sexual exploitation and abuse material, including the threatened distribution of digitally held materials. But you have to remind yourself that this is part of the solution. There is no one change to the criminal law that will forever, on an evergreen basis, keep everyone safe from emerging technologies. You need to look at those other pillars of the strategy that I led with in my opening remarks. Yes, stronger laws are an essential ingredient, but we also need to give law enforcement the tools that they need, including lawful access to digitally held information, which is the subject of a bill that's going through Parliament now. We also need to make sure that law enforcement receives the training that is necessary to combat this troubling frontier of digital crime that exploits people in a sexual way. In addition to those different pieces, we also need to look at whether there are non-criminal legislative reforms that we need to put in place to ensure that we're creating safe online environments for Canadian children. You have to look across society at the range of different policies that you can advance to protect kids online. Some of them that pertain to changes to Canada's criminal law are included in this bill, but that's only part of the job. So this is not a mission accomplished meeting. This is a step in the right direction that is so sorely needed and needed as soon as possible.
Thank you, Minister. And you spoke also about coercive control. You've met with experts and professionals in the field. You spoke about behaviors. Have they explained to you a little bit what kind of behaviors would fall under this category?
Sorry, in which category?
Under coercive control.
Certainly. So we're dealing with the kinds of circumstances that would involve violence in the home, including violence against pets in the home, which we know is predictive of violence against people who live in the home. We are dealing with sexual coercion. We're dealing with a range of different behaviors, but perhaps if I could encapsulate them simply, these are behaviors that would cause a person to reasonably fear for their physical or psychological safety. This is not someone who has a difference of opinion. This is not somebody who asks where a person went for coffee that day out of interest on how their day was going. This is a pattern of behaviors that we know are predictive towards violence, often fatal violence in a relationship. It's very serious, and we need to take action. We have made the decision to have a delayed coming into force to give time for the system to become ready to deal with these new challenges in response to very real feedback. We heard about the potential weaponization of coercive control against the perpetrator of an abusive relationship. But by enumerating sets of behaviors that would reasonably cause a person to fear for their safety, I think we've hit the right mark, as long as we combine that with training at a systems level to ensure that the courts have the ability and the law enforcement has the ability to move forward with this offense in the way it was intended.
Thank you. And often we hear victims saying how difficult it is to navigate the justice system. How will this legislation help provide them protection and a better way to go through this system while they are testifying or in any other event?
So there's a number of different ways, some of which directly impact a victim who's going through the system of a particular crime. Changes in terms of the standard for criminal harassment would be one example that I've discussed earlier. Dealing with new laws that currently courts don't consider, dealing with delays in the system where we've seen cases thrown out again because too much time has passed, not because the charges weren't made out. But in addition to these changes that will fundamentally shift the experience of the victim going through, which may lead to a conviction for the perpetrator. We're also including reforms to the Victim's Bill of Rights that makes clear there are certain entitlements to the victim in terms of the process that they should be able to take part in. The number of changes include putting clarity around their right to testimonial aids, their right to receive info about the process, so it will be shared proactively, the ability to make complaints to the victim's ombudsperson. There's a number of different reforms included when it comes to the Victim's Bill of Rights, but we've tried to go through to make sure that victims understand they have a role to play in the process, they have a right to have their voice heard, and they have a right to certain procedural aspects that make it easier to have their voice heard. So whether it's on the process side or substantive changes, we do expect these changes will manifest in a way that will markedly improve a victim's experience going through the court system.
Thank you, Minister.
Thank you, Ms. Dillon. Mr. Fortin, over to you for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Minister, on the question of inciting minors to commit a crime, this is a subject that really concerns the Bloc Québécois. I had worked on a bill on the subject. I think our approach was a little bit more, shall I say, robust than what you're proposing in C-16. I believe that that's actually one of the most serious crimes that one can commit, inciting a minor to commit a crime in one's place. It's cowardly, it's criminal, and it creates, or at least it risks creating a new type of criminal that will operate in a particular fashion. I think that's totally unacceptable. It's a major problem that we need to tackle. I had thought of saying, well, if you try to incite a minor to rob a bank, for example, provided there's enough evidence, you would actually receive double the sentence than you would have received if you had committed the crime yourself. That seems to me a way that might effectively really eradicate that problem. You're proposing 5-year sentences, I believe, for cases like that. Obviously, it's better than nothing. I'm not saying it's not a good idea. But again, I just found it a little bit timid. So I'm wondering if you would go further in order to crack down on this scourge, because it's often adults, often members of criminal organizations who incite minors to behave in this way.
Okay, merci.
Thank you. Before starting, I just want to really thank you. I know this is your idea. When we have discussions on the issues that you're working on, you always, bring these issues to my attention. You've talked about adults inciting minors to violence, and that's the reason that it's in this bill. So thank you. When I was considering the appropriate consequences, I looked at similar offenses that currently exist. So currently we have an offense of recruitment of people to criminal organizations. The sentence for that offense is 5 years. So if the committee's perspective is that we should adopt a different way of tackling the problem, I'm okay with that. You can propose amendments. You can work with the other members of the committee. And if my department is able to clarify, why we should choose one strategy over another, that would be possible. We would certainly consider those amendments. Thank you.
Yes, Mr. Lawton, over to you for 5 minutes.
Thank you, Minister, for being here. When Mr. Baber was asking you about the notwithstanding clause, you said something I felt was quite interesting, that you didn't think it was productive to engage in hypotheticals. Yet the Senville decision was the Supreme Court doing that very thing. It was the Supreme Court inventing a case that was not before it and using that to strike down mandatory minimum sentences that applied to the very heinous people that were at issue in that case, and that is Mr. Senville and Mr. Nod. So I'll begin there. Do you think it is reasonable for courts, for unelected judges, to use reasonable hypotheticals to override laws that parliamentarians have put in place?
I do think courts, and it's interesting you should say, use my desire not to discuss things in the abstract. Well, the courts use the hypothetical. I think it's actually important that courts use those reasonable hypotheticals that can and do, in fact, exist in reality. When they're assessing the application of criminal law that could result in a person's incarceration, they need to consider whether we drafted good laws. When we're drafting good laws, we need to make sure that we're trying to address real-world problems, not things that we think may exist. And I think the way that each body, as a function of the decisions we take as a government and a legal system, improves the quality over time of the decisions that are finally rendered and baked into our laws.
But as the dissent in Senville says, a reasonable hypothetical has to first and foremost be reasonable. The two cases that went up to the Supreme Court involved two individual men that had between them thousands of images and videos of child sexual abuse and exploitation material, children as young as, I think, 3 and 4 years old being subjected to absolutely heinous acts. The scenario the Supreme Court invented did not exist in any of the law before. It was not at issue, and pretty much every legal expert I've spoken to about this has said likely would never end up in that situation because of safeguards in place that would have prevented most likely a charge from even being laid under child sexual exploitation and abuse material. So my question is, why are we catering to this extreme case that does not exist in law, and in doing so, removing a very real and I would say very necessary mandatory minimum that is there to ensure that actual heinous predators are given a minimum, which I think is far too low, of 1 year?
So there's a couple of things that I'll offer in response. First, on the reasonableness of the hypothetical. First, let me say, we agree on how heinous the behavior was on the underlying facts that went to the Supreme Court, and I think every one of our colleagues, regardless of party, feels the same way, that we need strong laws to address such egregious behavior. The reasonable hypothetical that they cited involving somebody who aged out of a teenage relationship effectively is the kind of thing that exists in our society. And since that case has come up, I've actually had a few people come to me in a coaching, cadet program, teaching environment where they say, these things do come up, and we hope that you do crack down on the bad actors, but the 18-year-old who innocently received a picture probably isn't who you're thinking of when you think about child sexual exploitation and abuse material. So from my perspective, the use of that reasonable hypothetical is important to ensure that our laws capture appropriately the kind of egregious conduct that was the subject of the offenses committed in that decision.
Do you think some judges are too lenient?
Look, I would agree or disagree with an individual decision on a given basis.
I'll ask it in a more clear way, Minister. Do you believe that mandatory minimums are an important tool to prevent decisions that are too lenient for the facts at hand?
I have a different view as to why they're important. I think you want some certainty that certain crimes will be met with serious penalties, and I think that you have the opportunity to demonstrate as a society that certain behaviors will not be tolerated. So I support the reintroduction of these mandatory minimums that protect those in the books.
Because in the Senville case, you had judges that were actually ignoring existing mandatory minimums, even without a so-called safety valve. The Investigative Journalism Bureau analyzed 100 cases between 2020 and 2025 and found that one in 3 sentences for child sexual abuse material possession had not adhered to the previous sentencing minimum. So why is the existing minimum, even prior to the Supreme Court weighing in, not keeping these offenders behind bars?
I can't speak to what might be in the head of an individual judge for an individual case. The reasons may have varied between those cases. Suffice it to say, my view is that the mandatory minimum should be upheld, with the exception of these cases where it would be grossly disproportionate. So one of the changes that's actually being proposed in this legislation will help address the problem that you've raised by saying if you're going to deviate, you actually have to explain why. If you offer reasons as to why it would be grossly disproportionate, why society would be outraged, etc., then I could understand why you might see someone moving away. So I actually think in an exercise of transparency, this bill is not only going to restore the mandatory minimums, but give more clarity on the kinds of cases that you've just raised with me now.
Thank you, Mr. Lawton. Last round goes to Mr. Housefather for 5 minutes.
Thank you. Thank you, Mr. Chair. Thank you, Sean. Much appreciated that you're before the committee. I have a few questions, but before I get to my questions, I just wanted to enter into the issue of the notwithstanding clause because it sounds like our Conservative colleagues have been using their question time to argue that the notwithstanding clause should have been used here. Minister, the notwithstanding clause has never been used by the federal parliament, correct?
Yes.
And Jean Chrétien was the Prime Minister for 10 years during the course of time that the notwithstanding clause was part of the Charter of Rights. He never used the notwithstanding clause, correct?
And remains proud of that.
And in my recollection, there were cases during Jean Chrétien's time as Prime Minister, for example, Marshall on fishing rights, the same-sex marriage case, that Chrétien himself had said that he had reservations about, correct?
Certainly.
But yet he still managed to not use it, because using the notwithstanding clause is essentially saying that we have a protected right under the Charter, and we're, and we're going to say we're using it because we're not going to limit the right in a way that is reasonable in a free and democratic society. And by using the notwithstanding clause, we're essentially acknowledging that, correct?
That's right. You've articulated the limit that I think we should do everything we can to live within.
And there are alternatives to using the notwithstanding clause to get around a case, for example, like Senneville, correct? For example, rewriting the law to address the concerns expressed by the majority in the court decision, whether we agree with it or not, as you have done in this case in C-16, correct?
And more specifically, not only to address the concerns, but to achieve the same or greater level of public safety than exists given the laws that we have today, particularly in the context of mandatory minimums that are written in the code but have been struck down.
Exactly. Like, if we go to what exactly you have proposed in Bill C-16, you're essentially restoring the mandatory minimums, but giving the court the flexibility in a case where you would have one of these reasonable hypotheticals where it would be brought before the court, because nobody can be sure, no matter how long they were a prosecutor, that no prosecutor would ever bring such a case. You're ensuring that the court then will likely agree that the way the law is now drafted is reasonable. It's a reasonable limit on a freedom that is subject to the notwithstanding clause, because of the fact that the court has the discretion in that case, this rare case, to impose a lesser sentence, correct?
And I expect as a result of these changes, in fact, far more mandatory minimums will be upheld in the real world as a result of these changes.
I would agree with you. Can I ask you, Minister, one of the really important things that I don't think we've touched on is how much consultation you did to get us to this bill, because consultation is the key to making sure that we have legislation that multiple stakeholders and hopefully a consensus in Parliament will agree to. Could you just talk about the lengthy process of consultation you, your parliamentary secretary, and the department did with respect to this bill?
Look, certainly, and at risk of running out of time here, Mr. Chair, I think we should all acknowledge that we don't make good decisions if elected officials sit amongst one another behind closed doors and come up with an idea. There are people who are experts who have dedicated their lives, their careers, or are willing to loan their expertise earned through lived experience to inform what changes cause problems in people's lives and what solutions will avoid those problems for people going forward. We spoke with law enforcement, with victims advocates, with people who have been victimized by crimes, including sexual crimes, with people who have lost their family members to violence, and we want to respond to that very real-world phenomenon that too many people are being hurt, too many people are being abused, too many people are being killed. We want to breathe their voices into the laws that we adopt so we can offer protections for people who are living through circumstances that they continue to live with the consequences of every single day.
Mr. Chair, do I have any time left?
You have 1 minute.
Could I just then enter, Mr. Minister, could you just talk a little bit about how you decided to move towards the principles illustrated in the law to deal with Jordan? Like, what consultations did you do? Because I heard Mr. Fortin's comments, and I think it's important to talk about how much you consulted when you came up with the principles of what days would be reduced and so forth. Could you just sort of talk about who you talked to?
Look, very quickly, lawyers with experience in prosecution and defense, those responsible for the courts, law enforcement who are frustrated with cases that they have poured themselves into only to have the result be a stay of proceedings without it coming to its natural conclusion, and importantly, victims who have actually lived through this experience, people who have seen a crime committed against them go unpunished as a result of delays, not as a result of an accused person defeating the charges and receiving a verdict of not guilty. We try to understand the experience, and I'm sure you as an MP, like I have probably seen this injustice play out over the course of your career in politics. When you sit down with somebody who tells you that they were assaulted sexually and that the perpetrator lives in their community, was charged but let go because the clock ran out, I can tell you that doesn't feel like justice to the victim. It doesn't feel like justice to me, and we need to take action.
Agreed. Thank you so much.
Thank you, Mr. Housefather. Minister, thanks very much for being here today, and thank you for your time. We'll suspend for a few moments, and then we'll get to the second round. but there will be. What time are the votes? Okay. Okay, we'll get the meeting, call the meeting back to order, and I'd like to welcome the officials, and we're also joined by Chelsea Moore and Joanna Wells for the second hour, so thank you for joining us. We will jump right in, and the first round of 6 minutes will start with Mr. Lawton. Starting now.
Thank you very much, officials, for being here. Ms. Wells, I know you haven't gotten the opportunity to be at many Justice Committee meetings, so I especially appreciate you being here. I'd like to delve into the so-called safety valve, if I may here. And in the bill itself, I'll read it very specifically. It says, when imposing a sentence for an offence that has a minimum punishment of a specified term of imprisonment, a court shall impose a shorter term of imprisonment than the specified term if, in the circumstances, the minimum punishment would amount to cruel and unusual punishment for that offender. This is basically giving judges the latitude to ignore minimum sentences if they believe that minimum sentence would be cruel and unusual. But the scope of what this applies to, I just want to delve into here. In your understanding, could this section be invoked in a case involving aggravated sexual assault with a firearm?
So if this was adopted, it would apply to any mandatory minimum penalty that currently exists on the federal statute books.
Okay, so that would include aggravated sexual assault with a firearm?
If there's an active MMP in that offense, yes.
It would include human trafficking?
It would include any offense to which there is an MMP that is currently on the statute books.
So that would be extortion with a firearm as well?
It would apply to any MMP that is currently on the federal statute books.
And weapons trafficking then as well?
Yes.
Okay.
If that, I mean, I don't have it committed to memory. All the
Understand,
but an MMP, but if yes, it would apply. Like I said.
The reason I bring that up is because we have, and of course, then the offenses that were at issue in Senville, child sexual exploitation and abuse material, and the problem here is that we already have cases where judges are finding that, as in the Senville case, even 1 year was cruel and unusual punishment. So what consideration has been given as this bill was being crafted into ways to prevent this as being basically a way for judges who don't believe in mandatory minimums to simply ignore them if they don't want to impose them?
So I'll draw your attention to the language in 718.4 that proposes the standard of cruel and unusual punishment, which is the language that appears in Section 12 of the Charter. So it essentially incorporates the Charter standard into the criminal code, and the court's jurisprudence is clear that cruel and a sentence that reaches that level would be grossly disproportionate. That's a very high standard that would outrage the sense of decency, outrage the public sense of decency. So it incorporates a very high standard, and it would have to apply not to a reasonable hypothetical, but to the individual before the judge. So it would be a very much a tailored response to the offender that's being sentenced by the court if in that context the MMP would result in cruel and unusual punishment. The judge may depart from the MMP, but they must still impose a term of imprisonment.
But in the case of Senville, where Senville had hundreds of images of child sexual exploitation and abuse material, the trial judge did find that a 1 year minimum would be cruel and unusual, correct?
I don't know what the trial judge found. I do know that the one year penalty was imposed on Mr. Senville. That was the ultimate result, even though it was struck down in a reasonable hypothetical
It was 9 months.
I believe in now.
Or
it was
not,
9
sorry,
months.
not
Mr.
yet.
Senville received 1 year.
All right, I yield to Mr. Baber.
Under the criminal code, mandatory minimum sentences apply to a range of serious offenses. They're designed to set a sentencing floor to create deterrence, denunciation of certain crimes. But in recent years, courts have been striking down the mandatory minimum sentences as cruel and unusual, and that includes the Supreme Court. Now, this bill that we're looking at, Bill 16, the Attorney General points to Senville and recent jurisprudence where mandatory minimum was struck down for possession of child pornography. And to address this, the government is creating a safety valve that would allow courts to impose sentences below the mandatory minimum, where applying it would be cruel and unusual. So effectively, this would convert a mandatory minimum sentence from a biting floor and allow a judge to disregard it. So in practice, this means that mandatory minimum sentences will no longer be mandatory. Isn't that correct?
What it does is responds to, I mean, I think you could look at it that way. It provides judicial discretion to depart from an MMP in a very narrow circumstance when a judge is of the opinion that in the case before them, it would result in cruel and unusual punishment, i.e., it would violate the charter, because that is the charter language. So it provides a very small window.
But I understand that while jail would still be required, the duration of imprisonment would be left to a judge's discretion.
Correct.
And in practice, that means that the mandatory minimums that are prescribed by Parliament are no longer mandatory if a judge feels that they should not be applicable in any given case. And I submit that that is outright crazy. This will erode mandatory minimum sentences. It will result in lighter sentences for serious offenders. The Liberals are doing the precisely opposite of what is now required. Am I wrong?
So I think there's two things I would say in response to that. Currently, without an escape clause, what is happening, as the minister indicated, is that courts are striking the MMP down, so they apply in no situations. And so the proposed approach in C16 is to by adding this structured judicial discretion clause, it restores the mandatory minimum penalties that have been struck down. So they apply to the majority of offenders, except for those very narrow cases for which it may be grossly disproportionate.
Thank you,
for
Mr.
that
Babber.
offender.
You're out of time. In fact, you're over time. Ms. Latanzio, over to you.
Second point.
Ms. Latanzio?
Yes. Thank you, officials, for being here. So Bill 16 proposes a new offense related to coercive and controlling behavior in intimate partner relationships. Can you explain the legal elements of this offense and what would need to be proven in the courts for a conviction to occur?
Yes, thank you. That's an excellent question, and the offense has been carefully crafted to criminalize engaging in a pattern of coercive or controlling conduct, either with intent to cause the accused intimate partner to believe their physical or psychological safety is threatened, or being reckless as to whether that pattern of conduct could have this effect. So that is the mental element of the offense. The act element is, as I've said, engaging in a pattern of coercive or controlling conduct, and the amended offense, the offense would define pattern of coercive or controlling conduct as any combination or repeated instances of any three types of conduct. Those three types of conduct are violent conduct, including any attempted or threatened violence towards the intimate partner, the intimate partner's child, their animal, or anyone known to them, coercing or attempting to coerce the intimate partner to engage in sexual activity, or conduct, this third category of conduct, that could, in all the circumstances, reasonably be expected to cause the intimate partner to believe their physical or psychological safety is threatened. We refer to that as conduct that threatens safety. The first two types of conduct are criminal in and of themselves, while the third type of conduct addresses all forms of subtle, coercive conduct that could be engaged in by an abuser, provided that it has that a reasonable person in the victim's position would believe their physical or psychological safety is threatened. In order to give that provision life, the legislation includes a list, non-exhaustive, illustrative list of different types of coercive conduct. That list is taken from the lived experiences of survivors of coercive control. The approach is consistent with Scotland's approach, which stakeholders have told us is the gold standard, because it doesn't require the victim to testify that they actually feared for their safety. That's been a critical element.
Thank you. been made and have suggested that allowing judges to depart from a mandatory minimum is in very limited circumstances, would weaken the penalties. Can you explain how the safety valve actually helps ensure that these mandatory minimum sentences remain constitutionally sound while still requiring a term of imprisonment for serious offenses and offenders?
Thank you for the question. I think the minister also made this point when he was here earlier. What the escape clause does, it creates a situation whereby MMPs that are currently on the statute book that have been struck down by the Supreme Court of Canada or held to be inapplicable by other courts at other levels are reanimated, and they apply again. But it provides a small window of judicial discretion to allow judges to depart from a mandatory sentence in situations where they may otherwise have to strike it down or not apply it in that particular case because it would offend Section 12 of the Charter, the right to be free from cruel and unusual treatment or punishment. So in that respect, it reanimates MMPs that are not currently at issue while allowing for judicial discretion. And I would also maybe like to clarify that nothing, the fact that there is an MMP does not impact a judge's ability to impose an appropriate, the exception from the MMP doesn't impact the judge's ability otherwise to impose a just and appropriate sentence.
Okay. And moving on to the protection of online for children portion of the bill C-16. So several amendments of the bill will focus now on protecting children online, including changes related to child luring and sextortion. Can you describe how these changes expand the tools available to law enforcement?
Thank you for that question. So there are a bunch of different amendments in Bill C-16 that would directly address sextortion, including sextortion of children, which we know to be a significant problem. The first is an offense that would prohibit threatening to distribute child sexual abuse and exploitation material. That's intended to assist with proving sextortion cases because the extortion offense requires not just threatening behavior but also inducing the other person to do something, whereas this offense would apply to a person who threatens, let's say, a child to distribute CSAM without requiring that the purpose, proof of the purpose. And the same new offense would apply to intimate images, threatening to distribute intimate images in the world of sextorting adults. We also have an amendment in C-16 that would expand the child luring offense to ensure that police can use that offense when accused communicate with children in order to sextort them. So we call those preparatory offenses. They address conduct that occurs before the actual offense occurs, and that provides greater protection for children. There's also going to be, or there would be,
I'm going to have to ask you to wrap up.
an aggravating factor on the extortion offense in the case where it's sexual in nature.
Thank you. Mr. Brunel Duceppe, welcome to the Justice Committee. You have 6 minutes.
Merci. Merci, Mr.
Thank you, Mr. Chair. It seems that my colleagues had a lot of interest in the issue of mandatory minimum penalties. But C-16 talks about this safety valve, and it would transition that into judicial discretion. So what about MMPs that are deemed anti or unconstitutional if the sentence would be under the mandatory minimum? But they say that this is only the case if it's cruel and unusual punishment. So can you tell the court why you chose this approach when it comes to MMPs?
Si j'ai bien compris les questions.
So if I've understood correctly,
Sorry, I've lost my train of thought. Did you want to jump in on this one, or did you also lose your train of thought? Sorry. So on the MMP question, I think the objective of the change of the proposal is to allow judicial discretion in cases where, in the case before the judge, that is the case that they're hearing. In that situation, the mandatory minimum penalty would be unconstitutional. It would amount to cruel and unusual punishment. What's happening now before the cases is that often the case before the courts is not a case that would fall under that situation, but when the court does its Section 12 analysis, it looks to a reasonable hypothetical. And that is a case that often falls at the lower end of the moral blameworthiness spectrum, for which that MMP might not be appropriate, or for which it would be cruel and unusual. And on that basis, they strike it down. So the proposed approach in the bill is intended to focus the analysis on the offender before the court and protect the MMP by moving the analysis to the specific offender.
Est-ce que vous pouvez nous dire?
Could you tell us, what countries you looked to for inspiration in choosing this model? And with this bill, are we doing things differently than what's done in other countries?
So the model that has been put forward as part of Bill C-16 is really responsive to Canada's legal landscape and our jurisprudential framework. Has been the type of structured judicial discretion, or the fact that it is needed in the criminal space, has long been called for by criminal law experts, sentencing experts in Canada, and the Supreme Court itself has suggested that this type of structured discretion would be a way of preserving the mandatory minimum penalties in the criminal code. And so that's the model that we base it on, as opposed to looking internationally, because it was very much a made-in-Canada approach for the specific issues that we've been facing.
Et,
Which provisions about MMPs that are deemed inconstitutional could apply if this measure were adopted? Could you give us specific examples? That would be appreciated.
The best example to provide would be the mandatory minimum penalty of 1 year that was recently struck down by the Supreme Court in Senneville in October of last year. In that case, the court held that mandatory minimum penalty was unconstitutional and could not apply. It did not apply. It struck it down across the country. So by enacting this judicial discretion clause, or this structured judicial discretion in Bill C-16, that MMP, because it remains in the statute books, would be reanimated. It would now apply again going forward, so that but offenders that were charged with that would be evaluated under the judicial discretion clause. But the MMP would apply, and it's expected to apply in the vast majority of cases.
Merci pour ça.
Thank you for that. Now, when it comes to delays in the justice system, that's another very important issue. Some of my colleagues have raised it. It's a major concern, particularly since the Jordan ruling. How will the measures in C-16 allow us to reduce delays in the criminal justice system? Thank you very much for the question. First of all, it's important to recognize that the bill would maintain the incentives established by the Jordan decision, but it would also create new incentives. It would simplify procedures related to sexual assault cases, for example, which are known to be problematic when it comes to dealing with Jordan delays. It would set deadlines for filing in certain cases that are known to be problematic again. So we're taking a very targeted approach procedurally. There are also measures in the bill to simplify the administration of evidence, and measures that would provide more advice on complex files in order to ensure that the most complex cases are recognized as such. And when it comes to offenses against children, we know that those cases can often be very lengthy. Are there any mechanisms in the bill that would accelerate the processing of those files to avoid having victims wait years for the conclusion of the trial?
Time for a very, very brief answer.
I would just say that all of the measures dealing with delay would also apply to cases where children are victims. So certainly in more complex cases, they would be recognized as being more complex under this bill.
Thank you. Mr. Gill, you have 5 minutes.
Thank you, Chair. Good afternoon, everyone. Thank you, officials, as well. We all are here to strengthen and improve our laws and our justice system so that we can restore confidence among Canadians. Families expect firm consequences, not legal loopholes. With Bill C-16, are we strengthening public safety or create more legal challenges in court?
Maybe I'll take that question. Thank you for the question. I think the minister's talked in his remarks about the ways Bill C-16 would enhance criminal justice system responses to particular types of crime, gender-based violence, sexual offenses against children, sextortion, deepfakes, sexually explicit deepfakes as well. So certainly a range of new tools are being proposed that would address pressing public safety threats. I think the minister also talked about what the bill is trying to do with respect to mandatory minimum penalties, which is to ensure that they remain available for the range of offenses for which Parliament has already decided warrant a mandatory minimum penalty with a view to enhancing public confidence in the sentencing framework in the criminal law and ensuring that mandatory minimum penalties remain available in specific cases.
Okay. I know you talked about victims in this case, and I always say this, that it's time to put victims ahead of criminals. And does Bill C-16 give greater legal priority to victims over offenders? If yes, can you please point the clause? If no, why are victims still not the priority?
Sure. Thanks for the question. I might offer a few suggestions or a few examples, and then we're happy to kind of unpack those a little bit more. One example would be there are a number of proposed amendments that specifically acknowledge the impact that criminal justice system delays have on victims and require courts and prosecutors to turn their mind to those specific impacts when conducting an analysis around justice system delays. There's amendments in the Criminal Code and the Victims' Bill of Rights in relation to that. There are proposed changes to make testimonial aids easier to obtain for adult victims in sexual offense proceedings. This is something that the government had heard through consultations and through the work of Parliament, the victim's ombudsperson, that although there are testimonial aids in the Criminal Code, they can be more difficult or challenging to obtain in certain cases. So the bill seeks to make those more readily available for the victims that I've mentioned. And then, of course, as the minister has mentioned, there are a number of proposed amendments to strengthen the Canadian Victims' Bill of Rights.
Do you have the clause to mention which address this?
Sure. I can give you a couple of examples. So the, bear with me, so clauses 38 to 41 are the proposed changes to the testimonial aid provisions. Clause 46 is the clause dealing with delays. And then clauses, bear with me, I have it here, clauses 135 to 144 are the proposed changes to the Victims' Bill of Rights.
And whose decision was it to include the mandatory minimum penalty reform alongside the other gender-based violence proposal in this bill?
Yeah, so that was a decision taken by the Minister of Justice as the lead minister responsible for this legislation.
And did the minister office have any input in what went into this bill? And if yes, what was the input?
Yeah, I mean, certainly in our role as public servants, there's an ongoing conversation between ourselves and the Minister of Justice in terms of giving effect to the government's criminal justice system priorities. So we take guidance from the minister, we take guidance from the government in their platform commitments, for example, or in their speech from the throne.
Is it correct to say that Minister's office saw and approved a draft bill which included a broad sweeping reform for mandatory minimums, including with these other gender violence reforms?
Yeah, absolutely. So the government is responsible for its legislation that is introduced.
Okay. Who suggested the inclusion of making
Sorry,
intimate...
Mr. Gill, that's all your time.
That's time?
That's all your time. Okay. Okay, so next we have Mr. Chang. Okay.
So thank you for being here, officials. What resources or trainings will be required for law enforcement or prosecutors to effectively implement the new offenses, particularly those related to coercive control or online harms?
Thank you very much for that question. In fact, the minister did mention that there is a 2-year coming into force provision attached to the coercive control offense, and that is specifically to facilitate training that is being developed right now at the FPT level. So very targeted training to deal with some of the concerns that we heard during a 2023 stakeholder engagement process about potential unintended negative impacts of a coercive control offense, one of them being weaponization against the victim of the offense. So in the offense itself, there are some critical provisions that assist with avoiding or minimizing the possibility of that occurring, and that will form a central part of the training that's being developed and will be rolled out before the coercive control offense comes into force. And that's consistent with knowledge that we've gleaned from other jurisdictions that have implemented coercive control offenses. The success is largely dependent on effective training.
Thank you. And how will the government support smaller or rural police services in adapting to this new investigative requirements, especially in digital evidence cases?
Thank you for the question. And one of the ways that we work to support legislation that is enacted by Parliament is through engagement with our provincial and territorial partners. That takes many different forms. It can involve things like the development of handbooks, for example, to support police and prosecutors on implementing new legislation. It can involve webinars. It can involve knowledge exchanges. So these will be things that we would continue to explore with our provincial partners, who in turn, involve their criminal justice system actors, whether that be police officers from smaller communities, larger communities, Crown prosecutors, and others responsible for implementing changes to the criminal justice system.
Thank you. Do I still have time, Mr. Chair?
You have 2 minutes.
Okay. I will defer to Mr. Lattancio.
Thank you, Mr. Chair. So as we have begun this morning the study, I think it would be appropriate this time to put forward a motion with regards to the framework and the study of this particular bill, C-16, and I will read out loud the nature of my motion. So that the committee has begun its study on Bill C-16 on Monday, March 23rd, 2026, with the first hour dedicated to the appearance of the Minister of Justice and the second hour to departmental officials. That the committee hold 5 meetings with witnesses on March 25th, April 13th, April 15th, April 20th, and April 22nd, 2026. That following the conclusion of witnesses' testimony, the committee proceed to clause-by-clause consideration of Bill C-16 on Monday, April 27th, and I have sent both versions in French and in English to the clerk as we speak. Thank you.
Point of order.
Mr. Lawton?
Could we just do a brief suspension just to review the motion?
I was going to suggest we suspend because it's being circulated right now. Okay, thank you. We'll suspend. just heard from Ms. Latanzio with her motion. I believe Mr. Lawton wants to make some remarks. Mr. Lawton?
Thank you very much. And I actually appreciate the opportunity to have some direction on where we go as a committee from here. I think there is a lot of common ground between the parties on a lot of the parts of Bill C-16. But as we've discussed today in our interventions with the minister as well as with the justice officials, there are a few very key areas that I think need some more clarity. And I would love to go into clause by clause, having done a lot of the work up front that, as we've seen on previous bills that have come before this committee, is very important. I've seen the witnesses that have been proposed by all parties. There are a lot of witnesses. I'm not convinced that we will be able to get through them adequately in 5 meetings. I would propose a sub-amendment, and I hope that we can find some unanimous agreement here, to replace 5 meetings with witnesses on March 25th, April 13th, April 15th, April 20th, and April 22nd, 2026, with 9 further meetings. We do not take a position as to the timing of those. If we need to sit on break weeks, that's obviously an option. But that would give us time to get through all the witnesses that have been put forward by all parties. So that's the sub-amendment. I'd note that this is the size of the bill. It's 170 pages. It is quite substantive, and I want to make sure we're covering the issues.
Okay, we'll speak. Anybody's free to speak to your amendment, Mr. Lott. I just want to point out, though, if you're only proposing a change to the second paragraph, the third paragraph might need to be changed because I don't think we could complete it by April 27th.
Sorry. If there's unanimous agreement, what I would say is 9 further meetings, after which the committee proceed to clause-by-clause consideration.
Okay, all right. Okay, any comments? We're ready to vote. Okay, well, I'm not going to miss that opportunity. All right, Mr. Clerk.
Okay. Thank you. Thank you, Mr. Chair. So we'll go on the amendment from Mr. Lawton. Sorry?
Or no, it's just an
Oh, it's an amendment.
It's an amendment.
It's an amendment. Madame Latanzio.
No.
Madame Delin.
No.
Mr. Housefather.
No.
Mr. Chang.
No.
Mr. Baber.
Yes.
Mr. Gill.
Yes.
Mr. Lawton.
Yes.
Madame Cronis.
Yes.
Et Monsieur Brunet-Duceppe.
No.
Defeated.
Okay, amendment defeated, which takes us back to Ms. Latanzio's motion. Mr. Brunel-Duceppe.
Oui, merci, Monsieur le Président.
Yes, thank you, Chair. I wanted to amend Ms. Latanzio's motion as follows. Just at the end, I wanted to change this. When it says, April 27th, 2027, I would just add, and that subsequently the committee conduct the study proposed by Réal Fortin on judges as proposed on April 25th, or 23rd, sorry.
Sure, we can suspend for like 2 minutes. Does anybody have any comments on Mr. Brunel-Duceppe's? Mr. Housefather, you've got your hand up.
Oui, j'aimerais.
Yes, I just want to understand, Mr. Chair. There is a private member's bill that's before the committee. It was proposed by Ms. Hefner. And I'd like to know from Mr. Brunel-Duceppe, now, the Ms. Hefner's bill, would that also be studied after C16? Or is your proposal to do Mr. Feltin's study and to leave Ms. Hefner's bill aside? I didn't quite understand. Okay, well, logically, I think committees have 30 days to study a private member's bill. So there, obviously there would be commitments that the committee has. The idea here would be to prioritize the study after C16 and after all of our other committee obligations. So, but the first study that we would study after Bill 16, or maybe after the private members' bills as well. This is not normally my committee, but the idea would be to study Mr. Feltin's study, so I think that's pretty clear. I hope that I've answered Mr. Housefather's question.
Yeah, and just so everybody, I think you have, and just so everybody understands, that's C223, which has to be reported back to the House by June 18th. So we would have to satisfy those timelines and then proceed accordingly, as you've outlined. All right, any other comments? No? Okay, Mr. Clerk.
We have a number of private members. Do we not have any other private members bill in queue before our committee?
No. C223 is the only one.
223 is the only bill outstanding to the Justice Committee?
Yes.
Thank you.
Go ahead.
Okay. So on the amendment from Mr. Brunel Duceppe, should I read the amendment? All good? Okay. Madame Latanzio?
Oui.
Madame Dillon?
Yes.
Monsieur Housefather?
Oui.
Mr. Chang?
Yes.
We have Mr. Baber?
Yes.
Mr. Gill?
Yes.
Mr. Lawton? Oh, I'm sorry. Mr. Holman, I'm sorry.
Yes.
Thank you. Madame Cronis?
Yes.
Monsieur Brunel Duceppe?
Oui.
Carried.
Okay, sub-amendment carried. I'm only sad Mr. Fortin's not here. He's been trying to get this on the agenda for some time, and he's not here for the vote. Okay, so now we need to vote on the motion as amended.
On the main motion as amended, Madame Latanzio?
Yes.
Madame Dillon?
Oui.
Monsieur Housefather?
Yes.
Mr. Chang? Mr. Baber? No. Mr. Gill?
No.
Mr. Holman?
No.
No.
Oui.
Okay, motion carried. All right, thank you. We're out of time now for witnesses. I do have a couple of budgets, just one budget we have to get done. We have budgets for all of the various studies and whatnot we do. We're behind, and we hadn't approved the food budget for the time we spent on C9, which is the parliamentary equivalent to dining and dashing, because we actually had the food, we just haven't approved the budget to pay for it. So the budget total is, we're voting on a supplementary request addition of $15,000. The budget has been circulated. Everybody should have it in their inboxes for some time now. All in favor? Yes? Okay, all in favor? Yes? So, okay, motion carried. All right, thank you, everybody. Meeting adjourned.